Hi, I'm Olivia, a custody advisor with Wall Street Prison Consultants. Today I'm going to explain mail fraud defenses and penalties. Mail fraud is defined as the use of the U.S. Postal Service in any criminal attempt to gain money or things of value. The original crime carries its own penalties in addition to the penalties involved with mail fraud, regardless of whether the original crime is tax fraud, health care fraud, or any other number of possible offenses. In order for a federal prosecutor to convict a defendant of 18 U.S.C. Section 1341, they have to prove the defendant made materially false representations or promises with the intent to defraud another, and used the mail to accomplish the fraud. Put simply, the prosecutor must prove beyond a reasonable doubt that all of the following: there was a scheme to commit fraud, the defendant used the mail to advance their plan, and the defendant had a specific intent to commit fraud. Federal Statute 18 U.S.C. 1342 includes in a mail fraud crime of the use of a fictitious name or address for a fraudulent scheme. Fraud schemes often involve multiple actors. It may be that a defendant simply placed a letter in the mail at the direction of their employer or another individual. If you can show you weren't a part of the fraudulent scheme itself, your facilitation of the scheme, by mailing the letter, is not enough to convict you of mail fraud. Courts have held that the mailed items need not be crucial or central to the fraudulent scheme, and may be merely incidental. Still, your attorney will want to examine the government's evidence as to how the mailing of certain items played into the larger alleged fraud. It may be that the mailing is so unrelated to the purposes of the fraud itself that you can't be properly charged with mail fraud. The prosecution must prove its existence beyond a reasonable doubt to convict an individual of mail fraud. Therefore, if the defense can prove there is a lack of intent to commit fraud, the prosecution will not be able to make the charges stick. Mail fraud has a guilty mental state requirement that prosecutors must prove. Put simply, they have to show the defendant's specific intent was to defraud another. In other words, proving what they were thinking. Specific intent is not always easy to prove, as it has to show a defendant's state of mind. The federal prosecutor must prove the defendant knew that the information relayed through the mail was false, and they intended the fraud victim to rely on that false information. A defendant's actual knowledge, their state of mind and intent, and materiality of statements are all important issues on where to plan a strategy of defense. Mail fraud does not refer to a specific type of fraudulent scheme. Rather, it is simply the crime of facilitating a fraudulent scheme or conduct by utilizing the U.S. mail. There are two elements to the federal crime of mail fraud: 1. Devising or intending to devise a scheme to defraud, or performing specific fraudulent acts, and 2. Using the mail for the specific purpose of executing the scheme of the fraudulent acts. For example, suppose Party A decides to defraud Party B by purporting to sell a piece of property to B which A does not own. In the course of convincing B to forward the purchase money, A sends several letters to B containing false deeds, etc., showing A's ownership of the property. B relies on the information in these letters and sends the money to A. A can be charged with defrauding B as to the property sale, but also with mail fraud, as A utilized the mail for the purpose of attempting to execute the scheme. United States Code Section 1341 provides punishment for anyone involved in an attempt to fraud or swindle, who places in a post office mail any material to be delivered by the Postal Service. It also includes any commercial interstate carrier in an attempt to fraud or swindle. It states that a person will be imprisoned for up to 20 years. In addition, any violation that impacts a financial institution can lead to a prison sentence of up to 30 years and a fine up to $1 million, or both.